The Biden administration created rules that forced religious employers and healthcare providers to pay for transgender medical procedures and counseling, even if it violated their beliefs. Well, this week, a federal district judge temporarily blocked that mandate. In his decision, District Court Judge Daniel Traynor stated, "No government agency ought to be in the business of evaluating the sincerity of another's religious beliefs," end quote. The lawsuit was brought by the Christian Employers Alliance with the legal representation of our good friends at the Alliance Defending Freedom. And joining me now to discuss this is Jacob Reed, legal counsel for Alliance Defending Freedom. Jacob, welcome to Washington Watch.
Thank you, Joseph. Appreciate you having me.
It's great to see you. Tell us a bit more about the mandate that caused this lawsuit to be necessary.
Sure. So there's two mandates at issue here, one from the Department of Health and Human Services, and one from the Equal Employment Opportunity Commission. The latter forces Christian employers to provide coverage for so-called transgender health services, and the HHS mandate forces Christian doctors and healthcare providers to actually perform these dangerous and controversial so-called gender transition services.
So, Jacob, do these mandates apply to everyone? I know we're talking about some religious employers, but these mandates, as applied by the Biden administration, as they would like to apply them, cover all employers in the country?
Nearly all, that's correct. So anyone that is subject to Title VII, which is any employer with 15 or more employees. So that virtually covers, any medium to large size business, whether for-profit or nonprofit.
Now, unfortunately, we are not unfamiliar with mandates from the federal government. We went through a lot of this during the Obama administration. The Hobby Lobby case was successful. It was one that a lot of people were encouraged by, that said you can't force Hobby Lobby to pay for abortifacients against their conscience. How is this case different than that one?
Well, in many respects, it's not much different. It's very similar. There we were talking about abortifacients and birth control, et cetera. Here it's just it's more expansive. So now we're forcing not only employers to provide coverage for these controversial things, but to actually perform them, such as Christian doctors and healthcare providers. But it's very similar to the Hobby Lobby case. We're raising the same religious concerns. And the Constitution protects rights of Christian employers and healthcare providers to adhere to their religious beliefs.
So tell us about this decision from the judge today. It was good news. What was his reasoning here?
So the judge reasoned that the federal government violated what's called the Religious Freedom Restoration Act and the constitutional principles under the First Amendment by forcing CEAs, employers, and healthcare providers to provide or perform these dangerous and controversial services. And he held that the government cannot impose its own orthodoxy on Christian providers and employers, and that they have a constitutional right to adhere to their own sincerely held Christian beliefs.
But the case is not over. This is not a final ruling. Is that right? This is going to continue in court?
That's correct. So this was a preliminary injunction. So the federal government is prohibited from enforcing its unlawful mandates against the members as the case progresses. We're at the early stages, so we still have lots to do, but it is a great decision and it protects CEA members as we continue to go forward with this case.
Now, Jacob, if this case is successful, if the Christian Employer Alliance wins on their arguments, will that apply to all employers around the country, just members of the Christian Employer Alliance? Who is this decision going to affect?
So that's a great question. The current order we got just a few days ago protects CEA's current and future members. So it prohibits the government from enforcing the mandates against them. But as the case progresses, we have asked the court not only for that specific relief to protect CEA members, but we've also asked the court to enjoin these mandates nationwide. So there's a possibility that it could render these mandates unconstitutional across the country. That is yet to be seen, and we will definitely urge the court for that relief, and we'll see what the judge decides to do.
Well, it seems that the judge may have created some incentives for people to join the Christian Employers Alliance, because there does seem to be some legal benefits to doing so immediately and in the long term. But Jacob, if they did not succeed in court, if the Biden mandates did apply, what kind of penalties would be in effect for an employer who said, no, I can't do that?
Sure. So there's multiple penalties with regards to the healthcare members. So talking about the HHS mandate, they could lose all federal funding, and that would be Medicaid and Medicare payments. And as you and the audience is probably very well aware, that covers virtually all of the United States healthcare system. So that would devastate these Christian healthcare providers. And with regard to the employers, they could be subject to penalties, fines, private lawsuits brought by the federal government itself, which would be devastating and, could have severe financial impacts on these employers.
Which is why we are so thankful for you stepping up on behalf of the Christian Employer Alliance. And it seems like every week, and I know, in fact, earlier this week, we did talk to someone else at the Alliance Defending Freedom because of another critical case that you guys are advocating on the behalf of all Christians and really people of good faith and conscience and who love freedom. We're so grateful to you for doing it. And thanks for your time today.
Absolutely. Thank you for having me.